Rule 131. Burden proof, burden of proof, burden of evidence, and presumption. Section 1. Burden of proof and burden of evidence. Burden of proof, duty of the party of the present evidence of the facts is issue necessary to establish his or her claim and defense by the amount of the evidence required by law. Burden of proof never shift. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut of the fact. An issue to establish by prima facie case, burden and of evidence shall be shifted from the one party to the other in the course of the proceeding, depending the experience of the case. Section 2. Conclusive presumption. The following are instances of conclusive presumption. And whenever A is whenever party has by his own her on the declaration act of the omission intentionally and deliberately lead another to the believe a particular thing true and act upon such a belief. In his he or she cannot in the in litigation arising out of the declaration of omission by permitted to falsify it. Then V, that is tenant is not permitted to deny the little of his and landlord. Then at the time of the commencement of the relation of landlord and tenant between them. So section 3 is this disputable presumption. The following presumption are satisfactory if under under contradicted is but maybe the contradicted and overcome by other evidence. So A, person as innocent of the crime or wrong, then that unlawful is was done within lawful intent. Then the that a person intend to the ordinary consequences of this here voluntarily. Then that a person takes ordinary care for this is the concern. Then evidence will be willingly suppress the food of the adverse produce. Then the money paid by one of the another was due to the latter. Then G, that is a tiding delivered by one to another belong to the latter. Then that obligation delivered up to the boat then has been paid. Then then the prior rents and installment had been paid when the receipt for a latter one is produced. That is a person, third G, that is a person found the possession of a thing taken of doing the resent wrongful, then act of the taken is the does not the whole act. Otherwise, the things which the person possess then exercise act then over our own this were. Then that is a person K, that is a person possession of an order than himself. Then here is the payment of the money then to deliver, then anything has paid money of this delivered the thing accordingly. Then I, that is a person acting then the public was the regularly appointed to elected. This M, that is official duty was being then regularly performed. And that is a court, then judge is acting the suit that is whether the Philippines and also where was acting the lawful exercise of jurisdiction. Then O, that is that all the matters within the issue raised in the case were laid before. Then court, that is past, that is upon it is the like manner that is the matters of the issue raised and dispute, then submitted to the at arbitration, where this is arbitration is a pass upon by them. So that is a private letter P, that is a private transaction having this or regular. Then that is ordinary key, that is business, and queen. Then there must be sufficient consideration and contract. So that is a negotiable instrument was the endorse out sufficient in consideration. Then that is the endorsement to negotiable instrument was made before the instrument was overdue and place where this instrument dated. Then that is a writing truly detailed, dated. Then that is a letter duly that is directed to mean of the recipient. Then regular course, then more course of the mail. Then mailing, so that is after then absence then 7 years, then being unknown to whether not be subs, abs, absentee still be lives, then or she considered did, then purpose then accept then succession. Then the absentee that is shall not be considered, then not for the purpose of opening his or succession until after the absence of when the years, and he or she disappeared after rings, then 75 years absence he live, and shall be sufficient order then that his or her then succession may be open. So the following shall be considered did on the purpose, then including the division of the stable among the heirs. So one, that is only person that board this voyage, that is can be aircraft, then not be here then for years, then since is the vessel aircraft. Then two, that is a member armed then forces taken part of the hostilities has been missing for 4 years. Then three, that is being injured, that he can under the circumstances and those the expenses has not been unknown 4 years end. So absent spouse, then that is absent spouse that is already did, then case disappearance where the danger due to circumstances never herein above, then provide the absent only 2 years will be sufficient, that is proposed the contracting the absence and marriage. However, in a case before marrying again, so the spouse that is present must be provided finally family code, that is rules of the presumption that then absent is a prejudice, then prejudice to collect the appearance of the absent spouse. So